Okay, let's unpack this. Welcome to the deep dive, where we take complex information and transform it into clear, concise, and captivating insights. Today, we're plunging into a really crucial Florida Supreme Court ruling. It's got significant implications for open government, especially for those of you who follow open records law closely. Our mission today is to truly understand the 2016 decision in Board of Trustees, Jacksonville Police, and Fire Pension Fund v. Lee. This case it didn't just settle one dispute, it actually resolved a critical statewide conflict among Florida's appellate courts about attorney's fees in public records fights. It fundamentally changed the game for how public records access is enforced across Florida. So yeah, get ready to connect some dots. Let's start right at the beginning with the facts. What actually happened here? Our story centers on Curtis W. Lee, a citizen. He simply wanted to inspect and copy some public records from the Board of Trustees, Jacksonville Police, and Fire Pension Fund. Sounds pretty standard, right?
It absolutely should be. But what's fascinating here is that the pension fund wasn't necessarily saying no records ever. Their refusal was more conditional. They tried to impose certain conditions before he could see anything.
Conditions? Like what?
Specifically, they demanded an hourly photocopying fee and an hourly supervisory fee. Basically, pay us by the hour just to watch you look at the records and pay us by the hour to copy them.
Wow. Okay.
And Lee refused to comply. He argued those charges aren't right, they weren't proper under the law, and because he wouldn't agree, he was denied access when he showed up for his scheduled inspection.
So Lee, clearly believing in the spirit of open government, he did what you'd expect. He filed a civil action, and the trial court eventually sided with Lee on the substance, right?
That's correct. The trial court looked at it and said, yes, those two conditions, the hourly photocopying fee, the hourly supervisory fee, they were imposed in violation of the Florida Public Records Act, specifically Section 119.07, which is pretty clear about what agencies can and can't charge. So, yeah, a win for Lee on the merits. The fees were unlawful.
But here's where it gets, well, really interesting for the higher courts.
Exactly, because despite finding the pension fund had clearly violated the act, the trial court then denied Lee's request for attorney's fees.
Denied the fees. Why?
The court's reasoning was key. It said the pension fund's violations were, and I'm quoting here, not knowing, willful, or done with a malicious intent. So, in the trial court's view, because there wasn't bad intent, it didn't amount to an unlawful refusal, as required for fees under Section 119.12. That's the fee statute.
Ah, okay. So the denial of attorney's fees, not the fact that they unlawfully withheld records initially by imposing bad conditions, that became the central issue.
Precisely. That's what propelled this case all the way up to the Florida Supreme Court.
And the core reason it got there was this deep split among Florida's district courts of appeal, wasn't it? This wasn't just a minor disagreement.
Oh, absolutely not. It was a fundamental conflict in how different parts of the state were interpreting the exact same attorney's fee law in the Public Records Act.
So what were the opposing views?
Well, you had districts like the First and Second District Courts of Appeal. Their rulings, like in the Lee case itself at the lower appellate level, and another case, Gonzalez, they held a very firm line. Their view was, if a public agency violated the Public Records Act by denying access, there was no good faith or honest mistake exception. If there's a violation that prevents access, fees are due, period.
Okay, pretty straightforward, but other districts disagree.
Right. You had the 3rd, 4th, and 5th districts holding a different, much more, let's say, agency-friendly view. Cases like Althouse, Najam, and Knight Ritter illustrate this. These districts basically read the law to require a showing that the public agency acted unreasonably or in bad faith before attorney's fees could be awarded.
So under their view, an honest mistake could get an agency off the hook for fees, even if they broke the law.
Exactly. If they acted reasonably, in their view, even if unlawfully, no fees. This created this huge inconsistency. Imagine being a citizen in Miami versus Tampa trying to get records. Different rules on fee recovery. It really raised the critical question. Which way truly serves the purpose of open government in Florida?
So this lands on the Florida Supreme Court's desk. They have to decide. When does failing to provide records become an unlawful refusal that triggers those mandatory attorney's fees?
That was the million-dollar question. And the court's analysis really zeroed in on the specific words in Section 119.1. That section says, if a court finds an agency unlawfully refused to permit a public record to be inspected or copied, the court shall assess and award reasonable attorney's fees.
That word shall is usually pretty important in legal language, isn't it?
Crucial. It typically means mandatory, not optional or discretionary.
And the court ultimately sided with Lee.
They did. Squarely. They approved the view of the 1st and 2nd districts. Their ruling was crystal clear. A party who wins their public records case is entitled to statutory attorney's fees whenever the trial court finds the agency violated the act by failing to permit inspection or copying. Full stop.
So no extra step, no need to prove bad faith.
None. No additional requirement to show the agency acted in bad faith, without good faith, unreasonably, or anything like that. The violation itself is the trigger.
Wow.
And connecting this to the bigger picture, the court said this decision reinforces the whole point of the Public Records Act, transparency, letting citizens see what their government is up to.
Yeah.
Access to public records, they reiterated, is a cornerstone of our political culture. This ruling makes that cornerstone stronger.
That's a significant reinforcement. And you mentioned earlier, a lot of this seems to hinge on a specific change the legislature made to the law years ago.
Absolutely. Understanding that history is key.
Yep.
Originally, the law said fees were awarded if the agency had unreasonably refused access.
Unreasonably. Okay.
But back in 1984, the legislature changed just one word. Unreasonably refused became unlawfully refused.
One word. Seems small, but sounds like it had huge consequences.
Massive. Unreasonably refused kind of invites you to look at the agency's mindset, right?
Mhm.
Was their reason good or bad? Were they being capricious? But unlawfully refused strips that away.
Oh,
It just means, did the refusal comply with the law or not? Was it permitted by law?
so the focus shifted from the agency's intent or reasonableness.
To simply whether their action complied with the black letter of the law. The failure to comply became the trigger, not their state of mind when failing to comply.
So the pension fund and the districts that agreed with them, they must have tried to argue that good faith should still matter, right? Maybe pull it in from other parts of the act?
They definitely tried. They argued you should read a good faith standard into Section 119.12, the fee provision. But the Supreme Court explicitly rejected that. They basically said, look, the legislature knows how to write laws requiring knowing violations or willful acts or things done in good faith or reasonably.
They use those words elsewhere.
Yes. For instance, the criminal penalties in the Public Records Act in Section 119.18, they do require knowing or willfully and knowingly violations. And another part, 119.07 1cc, does say custodians have to acknowledge requests in good faith,
Ah, so the court saw that reference to good faith.
but interpreted it as strengthening the agency's duty to act in good faith when responding, not as creating a defense against paying fees if they later unlawfully deny access. The court reasoned that the absence of words like good faith or reasonable in the attorney's fee section itself was deliberate. If the legislature wanted that standard for fees, they would have put it there, just like they did elsewhere.
Makes sense. What about that PHH case, New York Times Come v. PHH Mental Health Services? That seemed to muddy the waters quite a bit for the lower courts. How did the Supreme Court address that confusion?
Yeah, PHH definitely caused some headaches. The Supreme Court really used this opportunity in Lee to clarify what PHH actually meant. PHH involved a situation where a private entity wasn't sure if it even counted as an agency subject to the Public Records Act at all. It was a fundamental question about their status.
Okay, so the uncertainty wasn't about whether they should release a specific record, but whether they were covered by the law in the first place.
Precisely. The reasonable uncertainty discussed in PHH was about the entity's status as an agency, not about whether an entity known to be an agency acted in good faith when refusing records. The Supreme Court basically said, look, if you are clearly an agency covered by Chapter 119, like the pension fund was, then refusing to allow inspection or copying is an unlawful refusal. The PHH uncertainty about status doesn't apply.
Got it. So that clears up a major point of confusion. Now, thinking about the impact, what does this all mean for you, the listener? Whether you're requesting records or working at an agency, the court talked about a dual purpose for these attorney's fees.
Right. They highlighted two key goals here. First, it's a deterrent.
Deterring agencies from saying no improperly.
Exactly. Discouraging agencies from wrongfully denying access. If they know an unlawful denial will likely cost them in attorney's fees, they're incentivized to comply voluntarily to get it right the first time.
Makes sense. And the second purpose?
The second is just as important. It encourages individuals to actually pursue their right of access. Think about it. If you knew you'd have to pay potentially thousands in legal fees to fight an unlawful denial, even if you were right, would you do it? Most people couldn't afford that gamble.
Precisely. This fee provision makes the right enforceable in practice. It ensures citizens aren't financially barred from holding agencies accountable. It levels the playing field a bit.
And this seems especially relevant to what happened to Lee initially, those hourly fees the pension fund tried to charge. Absolutely. The court specifically pointed out that unlawful conditions or excessive, unwarranted special service charges deter individuals from gaining access. Even if those fees weren't imposed with malice, the effect was to unlawfully obstruct access. The court said requiring citizens to pay lawyers just to overcome such unlawful barriers, regardless of the agency's intent, would gut the whole purpose of the act.
Now, this wasn't unanimous, though. There was a dissent, right? A different take on unlawfully refused.
That's correct. Justice Kennedy dissented. He argued that you shouldn't read the attorney's fee section, 119.12, in isolation. He pointed back to that other section, 119.071c, that requires custodians to act in good faith when responding to requests.
So he wanted to connect the fee provision to the good faith duty.
Yes. His core argument was that unlawfully refused shouldn't just mean unlawfully failed. He looked at dictionary definitions and argued refused implies something more active, a positive unwillingness to comply.
Hmm?
So in his view, if a custodian acted in good faith, even if they made a mistake and their action was unlawful, they wouldn't have shown that positive unwillingness. Therefore, no fees should be awarded.
Interesting. So for the dissent, good faith negates the refusal element, even if the denial was technically unlawful.
Essentially, yes. The dissent was worried the majority's ruling created a kind of strict liability for attorney's fees. Make any legal error in denying access, even accidentally or based on a reasonable misinterpretation, and you pay fees. They felt that wasn't supported by reading the statute as a whole. It really highlights a fundamental difference in how judges approach interpreting laws, stick strictly to the plain meaning of amended words, or try to harmonize different sections to find a broader intent. And there you have it. Our deep dive into Board of Trustees, Jacksonville Police and Fire Pension Fund v. Lee. The big takeaway. The Florida Supreme Court made it clear, for public agencies in Florida, if you unlawfully deny access to public records, you will pay the requesters reasonable attorney's fees. That shall means shall. Intent, good faith, honest mistake, irrelevant for fee purposes. The focus is simply, was the denial unlawful?
Absolutely. This ruling really put teeth into the enforcement of the Public Records Act. It makes it more practical, more accessible for individuals seeking transparency. And it sends a clear message to agencies. Know the law, follow the law, because unlawful denials, even inadvertent ones, have financial consequences beyond just having to eventually produce the record. The risk shifted. So wrapping up, something for you to think about. How does this ruling actually play out on the ground? Does removing that good faith inquiry for fees ultimately make government more open? Or could it potentially make agencies overly cautious, maybe even slowing down responses for fear of making any mistake, however innocent? Where's the balance? Something to mull over as you continue your own deep dives.